Thanks so much for joining us. So we have a great panel for you today, this evening, depending on where you are. Reimagining labor law, labor as cooperation and collaborative commons, towards new imaginaries, regulating work and ordering work relations. We're starting with Ania Zbyszewska, who will be speaking about labor as commoning practice, implications for regulation of work. We'll have about 15 minutes for each of the three presentations, and then we'll open up for questions. Feel free to put your questions in the Q&A as we go, or as they occur to you. We can always just pick them up later. And I'm Dr. Tara Mulqueen from the University of Warwick. Happy to have been asked to chair this panel.
Thanks so much, Tara. So my presentation is called Regulating Labor as a Commons, and I should say that it is still, based on work that is very much in progress. And in the time that I have today, I want to talk a little bit about the conceptualization of commons and commoning, particularly with the view to labor practices and relations. And I want to reflect on the possibilities that such an approach offers for foregrounding labor as a means of reproducing and sustaining other than capitalist relations and socio-ecologies. And I landed here kind of thinking about the commons in relation to work practices through reading Political Economy and Ecology, especially its feminist strands. And I've been doing this to work through my interest in the relationship between the material and legal articulations of labor, social reproduction, and environmental concerns, which are not that often attended to in labor law scholarship, though increasingly so. At the end of my talk, I will then briefly reflect on some sorts of questions or research avenues that conceptualizing labor as a commons or a commoning practice opens for those of us who are interested in how labor and work are regulated. And again, my comments here are preliminary. They're sort of thoughts really in relation to the things I've been reading and that I wanted to share. So why the commons? Before I got into law, I studied anthropology. And so my first intellectual encounter with the commons revolved around their social reproductive centrality in supporting diverse livelihoods, but also their enclosure and appropriation as the foundations for accumulation and emergence of colonial and capitalist social, including labor relations. Rather than limiting the commons to property forms or common natural resources on which livelihoods depend, in feminist political economy approach, bodies and social reproductive labor are also rendered as commons that capital seeks to enclose and appropriate through fictitious commodification of embodied capacity to labor for wage, or by rendering some forms of labor, whether free slave labor, for example, but also social reproductive labor like care, maintenance of life, but also local knowledges as freely available inputs. And from the historical far from being historically bounded to colonialism or nascent capitalism, these often violent processes of enclosure and appropriation have, of course, continued and arguably intensified under neoliberal political economy, privatization, globalized division of labor, particular forms of developmentalism, and the ever-present extractivism. At the same time, and as I also encounter in my kind of early encounter with ethnographic reading, but also then in my engagements with ecofeminism, Marxist autonomist, and feminist political ecology literatures, these process and the underpinning logics have been always actively resisted through plethora of non-capitalist praxis. Among them, commoning, or the actions of reproducing and reclaiming space and resources, both material and immaterial, for collective and communal sustainable use, management, and reproduction, has been a perennial practice of resisting enclosures and with it articulating and re-articulating relationships between community and space, labor and property, and enacting alternative and perhaps more sustainable socio-ecologies. And this multiple characterization of commons as sites of sustenance and closure, but also resistance, is what makes the commons so interesting from a conceptual and political perspective, namely commons illuminate the various entanglements, practices, and relations also of labor in ways that both acknowledge but also exceed their manifestations in capitalist political, economic, and social relations. So let me say a little bit more about how commons get conceptualized in general, and then the application of this concept to labor. So in more mainstream treatments, commons are conceptualized as a particular form of property regime, one in which property is held in common or collectively by a group of people or community, rather than being privately or state-owned. Within liberal theory, the key disagreement on the commons pertains to their viability as a property regime, with Elinor Ostrom and her colleagues' important and award-winning work frequently cited to affirm the commons, contra the thesis of tragedy of the commons. And Ostrom and colleagues affirm the commons, in a sense, by documenting empirically how existing commons are sustained and reproduced, and from those material realities then distilling some rules for their operation, although still on the basis of rational choice theory. And I believe that my colleague Paolo is going to speak a bit about this aspect of how commons is conceptualized. I personally am interested in approaches to conceptualizing commons from critical theory, which don't dispute the characterization of the commons as a property regime per se, but tend to emphasize the relational element of commons as the primary or an essential component of what a commons is. So in recent work, political economist Massimo De Angelis, for example, conceptualizes the commons as a living social system comprised of three elements: the common good, the commoners, so the social subject of the commons, and then the commoning, the activity of doing in common. And this articulation represents De Angelis's also response to critiques of his previous work by feminist political economists, among others. And so it's more in line with how feminist political economy approaches conceptualize the commons in sort of a agendic and relational way, and in which they cast the objects and subjects of the common as co-constituted through the process of commoning. So sociologist and ecofeminist Maria Mies, for example, observes that there is no community without there is no commons without a community, and no community without a commons. And some feminist political economists would actually say that engaging in practices of commoning can also build and bring about community. Importantly, as some feminist thinkers assert, this processual element or the practice of commoning is really the key to remaking commons. Commons both that pertain to situations where commoning, both that pertains to situations where an existing communal property is cared for and reproduced, but also those situations where that property had been appropriated by capital or state, and then is reappropriated, reclaimed, and reconstructed through collective efforts and a common practice. Or in fact, where new commons are built and come about through shared collective efforts and practices of solidarity. And this suggests that while commons are indeed often subject to capitalist enclosure, they're also, as Silvia Federici, for example, observes, transformational spaces capable of being regained and expanded through collective practice. In fact, for post-capitalist thinkers such as Gibson Graham, who urge us to see economies as hybrid rather than merely capitalist, the transformative nature of commoning process is such that a form of property being commoned is itself irrelevant. Private, state-owned, and open access properties are all capable of being commoned. And so this relational practice-based conception of a common as not just shrinking through capitalist enclosure and appropriation, but also capable of being expanded in diverse spaces, including within capitalism, is useful, in my view, for thinking about workplace commons as possible sites of non- and post-capitalist work relations. Worker cooperatives and worker recuperated factories and social enterprises have received much attention in literature, and they're obvious examples of workplace commoning. They're often, although not always, openly seeking to subvert capitalist logics. By prioritizing solidarity, cooperation, mutuality, and non-authoritarian relations, such forms of labor and ownership often carve out non-capitalist spaces, even when they are integrated into and reliant on markets. And my colleagues Andrea, Miriam, and Vladimir will be exploring cooperatives as sites of non-authoritarian work relations in a moment. It should be said that the potential of cooperatives and worker-recuperated factories has also been questioned, and in fact amongst mainstream trade union movement, but also amongst labor lawyers, though this is more anecdotal than anything, there is a skepticism around the transformative potential of these kinds of forms of work organization. And the reliance on markets, or what is deemed to be co-optation of co-ops and social enterprises through their enrollment into privatization of public services in places where such services were once state delivered, are kind of is the context in which some of these critiques come up. But as sociologists Marek Korczyński and Andreas Vittel point out in a recent paper, drawing on De Angelis, but also working in a sense in parallel with the feminist post-capitalist approach of Gibson Graham, such partial reliance on markets, even capitalist ones, need not fully undermine these practices of commoning or their value. Indeed, as they suggest, commoning can even take place in traditional workplaces that operate on what would seem entirely capitalist logics. And this is because, to quote De Angelis, commons exist both outside and inside states and capital. We find commons and commoning in the pores of social labor that capital cannot control, in spite of the always revolutionary management strategies, end of quote. And so with this in mind, Korczyński and Vittel cite sociological and ethnographic literature on work, which illustrates the many ways in which workers' collective actions create and recreate forms of workplace commons through, among others, community scoping and support, cooperation that increases individual autonomy within the labor process, acts of mutual assistance and sharing of tricks of trade, for example, between senior and junior or old and new workers. They observe that if we recognize that economies and economic practices are already hybrid, again in the spirit of Gibson Graham, rather than always and fully capitalist, then the mere fact that collective and cooperative practices may lead to surplus value creation for capitalist appropriation does not in itself preclude their contribution to the commons system, so long as the sociality that gives rise to these practices is not simply there because it is beneficial to productivity, but rather because it is an outcome of mutual care and solidarity. And I find this notion of commons making as capable of reproducing already post-capitalist relations, even within capitalism, really compelling insofar as its application to and transformative possibility in every daily practices of work as they already happen, rather than in some distant utopian future. And recognizing and celebrating these grounded practices, but also exploring them, I think, is crucial. At the same time, it remains hard to ignore the fact that commons and commoning-like ethics of the collaborative can be at times enlisted by states and capital in ways that directly seek to enclose and appropriate. Returning to labor, most recently, for example, invocation of the hero and public duty discourses in relation to frontline workers and other essential workers during the ongoing pandemic has operated to designate these forms of labor as a common good to be eventually appropriated for states or private benefit and profit, despite the fact that funding of public services has long been in attrition. While this example resonates with the caution that feminist scholars such as Mies or Ben Holt-Thompson bring, that capitalism always seeks to enclose commons and sometimes invents them for that very reason, I wonder whether the post-capitalist optic helps us here. Can the public recasting of care and other frontline work as a common good, even if it's made for instrumental reasons, ultimately pave the way for its actual recognition and recommoning in a move that feminists such as Silvia Federici have called for in regard to care and housework, for example? Or to return to the earlier point that Korczyński and Vittel make, if the sociality that underpins and is generated by this commoning of care and social reproductive labor exceeds the desire to merely remake capitalist societies and markets, perhaps such potential is present. if it seems that I'm going between this cautious and pessimistic notion of the commons, on the one hand, as always being enclosed, folded in and co-opted, and then the excitement about the promise and possibility they offer to ways beyond sort of the capitalist enclosure, it is because I'm not sure quite how to reconcile the two, and indeed because they often coexist together. But what are some implications of thinking about labor as a commons or a commoning practice for how labor lawyers might engage with all of this in rethinking how labor is or might be regulated? And I think I'm struggling with this a lot as well. So there are a couple of ways that I'm thinking of that law and work regulation issues can be explored in relation to this issue of commons and commoning. And they sort of mimic that duality of caution about enclosure and promise of transformation that I signaled earlier. One, the ILO has taken keen interest in cooperatives, social and solidarity economies for some time now, linking both to decent work agenda and to the UN Sustainable Development Goals. Interest in solidarity economies and social enterprises have also been expressed in mainstream policy in relation to addressing precarious work, unemployment, labor market exclusion, informality, etc. I think a closer look at these policy calls and developments, especially insofar as how they frame solidarity economies vis-a-vis mainstream economies, could be really interesting. To what extent are these also efforts to fold the fringes and margins or alternatives into the mainstream fold, or do they hold promise to transform how we think of work in general? On the other hand, or the second idea is the fact that work regulation scholarship is now increasingly interested in grounded practices of work, especially in contexts once marginal, but now becoming more ubiquitous, such as contract and gig-based work, rather than collective labor relations. And I'm thinking, for instance, of Ruud Dux's work at the moment. Why not expand this also to looking at cooperative and social enterprises and ways in which conditions of work are negotiated and experienced in those kinds of places? Looking to these grounded practices of work, but also to collective resistance, or to maybe use Adele Blackett's term transgressions, through practices of commoning and otherwise, what can we learn then about law of the workplace from those practices? And that's really all I have for now, and I think I've gone over my time in any case, so thank you for your attention.
Thanks so much, Ania. That was brilliant. And you were only over by a tiny bit, so absolutely fine. Okay, great. So again, we'll come back to take questions after everyone's presented. Next, we have Paolo Tomassetti, who is going to be speaking about the utopia of the commons, a spring for labor law and trade unions. Go ahead, Paolo.
Thanks, Tara. Good evening, everyone. I'm from the University of Aix-Marseille. I will present this paper about the implications of the commons theory and practice for labor law and industrial relations. I think from a different angle of the one that Ania just discussed. I will focus on the commons as legal category, mainly drawing on civil law scholarship, mainly Italian civil law scholarship like Stefano Rodotà and Ugo Mattei. The overall assumption of my presentation is that commons are the opposite of property. So I will basically develop my argument against this background, non-property background of the commons, and I will try to understand what can we learn as labor lawyers from the theory and practice of collaborative commons. Are conventional labor law justifications fit to frame and investigate the idea of work in the commons, the idea of work in this non-property dimension? So following these questions, I begin my paper by investigating and criticizing the big dichotomies between the state and the market, the public and the private law, and the correlated articulation of property rights into public and private domains. And in the first part of my article, I contend that these dichotomies are complicit with the current socio-ecological crisis, claiming with Elinor Ostrom that neither the state nor the market is uniformly successfully in enabling individuals to sustain long-term productive use of natural resource systems. And through this argument, I come to introduce the commons as such a legal institution alternative to the public and private property divide. And I therefore present the commons' main characteristics, and I contrast them with the labor law and industrial relations frames of reference. And in this regard, I make three broad claims that I would like to discuss with you today. First of all, I will argue that traditional labor law justifications are unfit to frame the idea of working collaborative commons, and the same goes for classical industrial relations frames of reference. Secondly, I will maintain that the ideal typical function of the commons that sees the corporation as commons, it is useful for many purposes, but it lacks analytical capacity when it comes to assess the structure of the employment relationship in capitalistic corporation, which in my opinion remains unchanged in contrast to the traditional shareholder conception of the firm. And finally, a little bit beyond the actual content of my paper, I will try to elaborate a bit on the similarities and differences between the commons and cooperatives, so to bridge Ania's discussion with the one of Vladimir, Andrea, and Miriam that will follow. In this respect, I will discuss what, in my opinion, is the main theoretical and practical distinction between these two institutions, having in mind the idea that the commons are the opposite of property. And I will maintain that cooperatives are an exception to capitalism, while capitalism is an exception to the commons. I now go through these three arguments and try to briefly elaborate on them further. So why mainstream labor law justifications are unfit to frame the idea of work in the commons? To answer this question, I assume that the conflict of interests underpinning the employment contract and the employment relationship in traditional productive industrial work fades away in work activities within collaborative commons, the commoning. And the same goes for trade unions' logic of collective action and building solidarity to coordinate individual interests towards broader social goals. And in order to support this argument, in my paper, I discuss the legal characteristics of the commons, how work in collaborative commons is performed, and what are the main differences with capitalistic employment relationships. I don't have time to go through this discussion now, but the analysis is clear that work in collaborative commons is largely incompatible with the pluralistic assumptions of both labor law and industrial relations frames of reference. In fact, while the legal contract of employment assumes conflict of interest between employer and employee as inherent in the employment relationship, work in collaborative commons is based on the existence of a common purpose. And this common purpose flows from solidarity between the commoners, within the commoners, and between the commoners and the common resource itself. And such solidaristic dimension is not functional to achieve either private, collective, or even general interests. It is functional to guarantee the sustainability of the common pool resource. So if on the one side, labor law and industrial relations institutions following Durkheim work to promote organic solidarity in capitalistic labor markets, on the other side, social ties and work relationships in collaborative commons are based on mechanical solidarity. And through these arguments, I conclude that traditional labor law narratives are largely unfit to frame the idea of work in collaborative commons. The second claim I make refers to the ideal typical function of the commons theory as presented by Simon Deakin and others. This scholarship sees the corporation as a collectively managed resource or commons, which is subject to a number of multiple, overlapping, and potentially conflicting property type claims. Viewing the corporation as a common, Deakin argues, is the first step towards a better understanding of the role that corporate form can play in ensuring wider economic and social sustainability. Now, in my paper, I underline that this argument is strongly consistent with, again, the pluralist theory of industrial relations institutions as elaborated by the Oxford scholars between the 60s and the 80s. But in contrast to work in collaborative commons, it doesn't add anything to the theory of the employment contract and relationship, which in capitalistic firms, in capitalistic corporations remain unchanged. Therefore, the idea of corporation as commons should be taken as it is, a useful theoretical framework to describe the legal structure of a business enterprise better than the shareholder primacy model does. But viewing the corporation as a commons would not necessarily help deliver benefits for all of its stakeholders and for society as a whole. And this is basically because in capitalistic firms, employees, unions, and other stakeholders' voice is precluded from core decisions regarding property rights and the correlated economic freedom to choose how much, where, and above all, why and for whom human and natural resources are extracted and exploited to produce value. And now I go through the final part of my presentation where I want to contrast the commons model with the cooperatives one. I will proceed by briefly underlying institutional and functional similarities and differences between these two institutions, having in mind the assumption that the commons are the opposite of property. First of all, there is consensus that both cooperatives and the commons emphasize social values and solidarity over profits, and both employ democratic forms of managing their operations. But while cooperatives are owned, commons, again, have a non-property nature. They are the opposite of property. And I think this is an unbridgeable gap between the two institutions. I'm pretty sure I would be criticized a lot, but this is consistent with my assumption. Despite this, cooperatives can be one of the institutional forms to give legal recognition to the commons, even if not all commons should be necessarily managed through the cooperatives model. Collaborative commons, for example, can be organized and legally recognized through an association, a foundation, or even without any formal juridical status, as it is in the reality. Another relevant difference is that cooperatives focus on community and groups, while the commons focus on resources sustainability. And this implies that cooperatives work for the interest of people and communities involved, and not necessarily for the future generation. Commoners work for the actual and future sustainability of common pool resources. Taking these considerations together, I conclude that the most relevant distinction between the two institutions from a labor law perspective is that the employment contract in cooperatives is still an exchange contract. In contrast to the idea of work in the commons, cooperative workers pursue an economic interest, although the solidaristic dimension of the relationship is higher compared to the employment relationship in capitalistic firms. I guess my time is finished, so I'll stop there. Thank you very much.
Thanks so much, Paolo. Those are some very valuable critiques. Okay, so our final paper is co-authored by Vladimir Bogoeski, Andrea Iossa, and Miriam Kullmann, and it's titled Worker Cooperatives as Real Utopia, Notes for a Progressive Labor Law Research Agenda. Take it away, guys.
Great. Thank you so much, Tara. Really, I kind of really like how our paper fits in with the previous discussion, and I think it's great because we can build on a bit more on Paolo's presentation, but also some insights from Ania. And before going into the paper itself, I would just say that Miriam and I will both talk, and first I will just give a bit of a background how we actually came to looking into the cooperatives idea in the context of labor law. I will talk about actually the main what we see as the main connection point between the cooperatives and labor law, and then Miriam will say a bit more on the cooperative values that we were discerning in the paper that can lead to some insights that we can incorporate in labor law scholarship. But as to our paper, it's very sort of exploratory paper, and we went into it really for the sake of exploring what can we get out of for labor law thinking, something that that shall advance, as we say in the title, a progressive labor law agenda through insights from the cooperatives, both currently like looking into the discourse around cooperative, but also looking into different examples and what can we learn from them. So following up on something what Paolo said, and actually I found this very interesting, the distinction that you've made between the cooperatives and the commons, the final one, that cooperatives is more community focused, while the commons are more sustainability resource focused and more sort of more inclusive and more attentive to environmental questions. I think it's really interesting, but probably true. But one of the factors that draw me personally to look into cooperatives was because some of them who have explicitly like a socio-ecological agenda sort of connect these two issues. So the one is the sort of social values, but also environmental values. Like it's really interesting now. I've been looking into some cooperatives in the Netherlands, for example, in the agricultural industry that really kind of have also a strong emphasis on the environmental side and on the social side. So I've found that very interesting as a starting point, taking some of these cooperatives as because I think as labor law scholars, and particularly Paolo and Ania, you're doing some work on the environmental side in relation to labor. And I think except for some exceptions like you, these two discourses sort of run on parallel, the environment and the labor. And so this was one point, drawing particularly myself to cooperatives, this sustainability and the labor factor. And the other point was the more classical one, because the three of us sort of saw the cooperative as a form of workplace or a form of organized economic activity that involves labor that is explicitly challenging the labor relationship as it's been constituted on the basis of the subordination of labor to capital. And actually that draw our attention to the cooperatives, because we have this example of work. And not all cooperatives are the same, and Paolo was right. In some of them, there are work relations that really resemble classical sort of work relationship based on an employment contract. Not all workers in a cooperative space are members. There are also members, employees, and etc. There are some more classical relationship, But the idea of the cooperative as it emerged in circles of socialist, anarchist, utopian thinkers of the 18th century was very much focused on horizontal work relations based on solidarity, collectivity, and similar values, on which Miriam will say something before, that where the workers own or govern the means of production. So, and we find this idea quite interesting and quite central, and challenging one of the like sort of assumption that we rarely contest also in labor law scholarship, that sort of the relationship between capital and labor is one of hierarchy and subordination, and then we have labor regulation and labor law that sort of make this sort of condition of the working person more bearable, while the cooperatives is straightforward challenging this idea. So that was one of the sort of first insights. And as Paolo like justly emphasized, that's the idea that's also attractive in a way to advance our thinking and how to think of regulating and ordering a work relationship in future stands already in some contradiction to basic ideas of labor law, or how so if we have a workplace where we have relations of horizontality, solidarity, collectivity, where there is no this classical relations of subordination between labor of capital, where do we still have place for labor law? So that's also a source of skepticism and some towards the cooperative ideas. But also in our research, in the paper we have a part that is called Taxonomy of Cooperatives as a source for different ideas and approaches to the cooperative that can yield some insights for labor law. And through this part of the paper and going through different forms of cooperatives, not only, let's say, worker cooperatives, producer cooperatives, consumer cooperatives, etc., we are only focusing on worker cooperatives, but sort of we can already see that there is not a homogeneous form of the cooperative that we can take and study and draw insights, but in every single cooperatives there are different in a different given social legal context, different work relations emerge, and that's also quite interesting to look into. And we had a panel on platform cooperatives yesterday, and that was really interesting. They had some empirical research to see how, I mean, that's also an expected insight, but also quite interesting to see that the bigger the cooperative is, so the lower the commitment of members becomes. And then you have some emergence of more classical corporate structures and different bodies of decision-making processes emerge, and so definitely something emerges, an environment that requires some intervention through different rules, through different regulation that would intervene in some emerging structures of hierarchies and subordination in an environment that was originally thought to be based on principles of horizontality, collectivity, non-hierarchy, etc. So I will just give the word to Miriam now to go into the values that we were looking into, the values that are underlying the cooperative idea. And so Miriam, the floor is yours.
Thank you. I think this was a great panel already, very fruitful, and many ideas to think about. But starting from the idea that we wanted to find out what a cooperative could possibly mean within a labor law context, also because within labor law scholarship, a cooperative has not been addressed that frequently and not in depth, at least not in continental Europe. So but also challenging the idea of the capital-labor relationship. We also focused on identifying potential values that underlie the work cooperatives in particular. And so what is actually the glue that keeps a cooperative together? And one of the challenges Vladimir mentioned based on his other research is that the larger a cooperation gets, the more difficult it becomes, as we see, to keep up a certain values that were the key drivers to have a cooperative. While worker cooperatives can be seen as institutions within which a group of workers or individuals has decided to predominantly, mostly economically, but it may also, of course, be broader, to cooperate to serve the group's defined self-interest. Worker cooperatives may also serve, of course, societal interests that go beyond this economic work relation. And what Beatrice Webb helpfully refers to as the cooperating body of workers, in which workers work with and for others. And the glue, it seems, that keeps these some worker cooperatives at least alive is cooperation. And worker cooperatives in general are united in their commitment to running themselves along collectivist democratic lines, and they generally make decisions by direct dialogue and consensus. So at the core are this individual voice and human cooperation, which is defined by and requires a kind of social bond between the members that is cooperative in nature. So cooperation then means that property is socially and or collectively owned for an egalitarian decision-making process that would otherwise not be possible. Yet this importantly, of course, presupposes that the group is willing to search for common ground through sustained dialogue, and moreover, that all relevant information and relationships are shared among the group members. Finding and defining unified interests then is a sort of cooperative democracy that reduces inequalities of influence while encouraging individuals' voices. However, finding unity of interest might be hard to achieve. But research has shown that workers who have been working in cooperatives for many years learn to identify with the group's needs and interests and not just their own. So again, relying on Beatrice Webb here, a cooperative community understands democracy as a form of association whereby the whole body of the people acquires a collective life. So what kind of particular values underlie worker cooperatives as a collective? The two most prominent values that we see in the literature, but also among the cooperatives, are democratic member control, where there's an active participation in setting policies and making decisions, and member economic participation, which refers to the equitable contribution to and democratic control of capital of their cooperative. However, there are also other core values of cooperatives, which are voluntary and open membership, but also within that value to accept responsibilities of membership, but also autonomy and independence, and another one also education, training and information, as well as cooperation among cooperatives. And finally, also concern for communities, such as work for sustainable development of their communities through policies approved by their members. So here we see a more larger societal dimension embedded in one of the core values. Democratic member control and member economic participation are built into the cooperative form itself, the central value being democratic control by its members. Yet another question we were dealing with, and then we will move on to our finalizing words, is how do these values actually relate or understood within labor law? We know workers having voice through co-determination, participation, but the cooperative and the values we have seen are, yeah, how do they relate to labor law? So when looking into these, how worker cooperatives function within the existing labor market structures, we find that even though workers are owners and can control production processes, the cooperative still is cooperating within a capitalist market as we know it today, and therefore also competing to some extent at least with traditional undertakings and corporations. Yet worker cooperatives do challenge existing structures, as we have heard already. Yet in labor law, worker ownership, if we stick to the core idea and the core notions labor law is dealing with, would be translated into the worker being a self-employed person as he owns the means of production. And also one aspect Ania is researching or has been done a lot of research already is that non-wage labor is not always recognized or not recognized at work at all, as is the case with domestic and reproductive work. So overall, looking into these values and into the core concepts of labor law, we find that the idea of a work cooperative is not yet well suited to be covered by at least not traditional labor law systems. So there's, at least for us, much more work to think about and to discuss, of course. So I think, Vladimir, we're going to the finalizing words. Right?
Yes, thanks, Miriam. I think we are both within the 15 minutes somehow, so I'll just maybe we'll wrap this out with putting out some questions that that we had at the end of the paper and that we've been struggling with. I mean, no matter how drawn we are to the idea of the cooperatives as an alternative to the, let's say, to the capitalist mode of production and a capitalist mode of organizing economic activities and work relations, there are some serious tensions out there, and particularly in the context of labor law. And it's not so easy to find an angle on how labor law can draw concretely on insights from the worker cooperatives. Some obvious questions that we had were, okay, what is, and Ania, you rightly pointed out to grounded practices, and that they do not really we don't really always have to try to find a way how some grounded practices are coupled with forms of organized labor as we know it now. But the question is out there. So I mean, if we look into these grounded practices, and particularly in the cooperatives that we were looking into with Miriam and Andrea, the question is there. So how do these practices relate to collective actors, to organized labor and its current form? Where are unions, for example, in these structures? I mean, if in the pure idea of the cooperative, there is no really, so there is no form of organized labor in a classic sense, because workers are owning and governing the means of production, and they're making decisions in a collective horizontal level. So the idea is that there is not the question that different forms of collective bodies will emerge, or different bodies of different different vote possibilities or different voice expressions bodies will emerge, but how will this relate to the existing labor movement or to unions and etc. So that was one question. And the other another tension that was how the cooperative idea materializes in some context which is opposite of ideational intentions. And Miriam mentioned the self-employment, and actually in particular context, the social appeal of the cooperative idea has been exactly particularly exploited in a sense to deprive workers from labor rights. So we have different studies, and I think a colleague earlier mentioned the study or a case of Brazilian taxi drivers where the cooperative form has been particularly abused in terms of depriving workers from right. And all this context. So that how these ideas actually materialize in practice, of course, does not affect the attractiveness of to explore these forms, to learn from them, from ideas and from practices that actually materialize in a good, appealing way. But these tensions exist and are part of our our direction of further thinking, and actually how can we think of this in terms of our paper. And I don't know if Miriam, you would like to add something to that, or should we? Yes, okay. So thank you. That I very much look forward to the discussion and will not take any more time.
Thanks so much. That was brilliant as well. And I think the papers all speak to each other in really interesting ways. We don't have any questions, I think, from the audience or attendees just yet, but I have kind of a question, I suppose, for each paper, but I'm happy, I don't know, we can be kind of informal and relaxed. I don't know if that just kind of turns into open discussion. I think that's probably also absolutely fine. But I'll let you know if we get any other questions on the Q&A. Do you guys mind if I just ask a couple questions that occurred to me while you were speaking? So Ania, I'm really excited by and kind of sympathetic to the sort of position that you're outlining, and in particular the idea that these kinds of commoning practices, you know, exist within capitalism, and it's so important to be able to see them and recognize their value, and not just assume that kind of all of our social relations are completely subsumed within the capitalist system, which is a really dire, I think, political outlook to have. And I think that's the real value of that kind of work. But I wondered as well, you talked about needing to be cautious. And so I wondered, so what does that look like? What does it look like when we're kind of bringing caution to how we look at these things? Because I do think, you know, if you look at Gibbs and Graham, they do slide into a certain kind of apologism at times. And like, you know, in like post-capitalist politics, for example, like they're really like, they speak in very like positive terms about USAID and some other things that like, I think we could probably pretty easily sort of take apart. And so I wonder just for you, where does that caution come in? What does it look like? And I think one of the things that you said was, and you were quoting somebody else, that, you know, it doesn't actually matter who owns the thing, that like it could be state property, it could be privately owned, and we can common, you know, in relation to that. I'm sorry if that wasn't you, Ania, it might have been somebody else. But I kind of wonder, like that kind of question, for example, you know, like at whose pleasure are we able to common? And so doesn't the kind of fundamental question of ownership actually matter in the end, even if we can have these practices, albeit in very important ways? At the end of the day, if we want to transform them into something more than just marginal practices, that question of ownership perhaps comes back in. So those are my questions for you. Paolo, I wondered if, in thinking about all of the kind of structural barriers, I mean, the corporation really is kind of the antithesis of the commons, so I'm not sure what Deacon's arguing, but I wondered if you've given much thought to what alternative legal structures look like. And in particular, I was thinking about Janelle Orsi's work about practicing law in the sharing economy. I don't know if you've ever come across it, but just thinking about like, how would our norms and our kind of legal models around employment, embedded as it is in the kind of master-servant relation and then employer-employee, how would those need to shift in order to be something genuinely alternative? And with that, sort of, what does it look like, again, if we go from commons being kind of subsumed within these structures that are quite constraining to structures that actually enable and support it? So if we get rid of the private-state dichotomy and actually just embrace commons, what does that start to look like from a legal perspective? And where are some of the ways in which we can, you know, try to experiment with that and play with that? And then for Vladimir, Miriam, and Andrea, I was wondering about, and this is my own kind of personal bias, I suppose, or just my own interest, is the history of cooperatives and where they come from. Because they tend to be seen as alternative, and I think you've already pointed out that they're not always, and they can be lots of different things. But their history at least, so I've studied them in a UK context, is really problematic in the sense of the way in which they emerged, in particular the way in which they secured legal recognition. It was very much about disciplining the working classes as opposed to enabling them to have some kind of genuine alternative. And so to that end, like, they're kind of legally designed to be subjected to the market economy and marginalized within that, which again isn't to say you can't do things with that framework, but the ways in which that kind of structure might be sort of inherently limiting, and the limitations of kind of just talking on the register of values as opposed to the kind of underlying structure, which has given us the notion of the cooperative as the alternative, or as an alternative. And if we need to like try to push beyond that somehow, which I think you're already doing, so it's not so much a challenge to what you're talking about at all. Okay, I'll stop there. Yeah, and also feel free to talk about whatever you like. You don't have to answer my questions at all.
Should I start perhaps, since the comment and question was for me? Yeah. The first one was for me. I mean, we all get comments and questions from Tara, but should I begin? Yeah, Tara, I should say that, and you perhaps maybe know this, but I was drawn to J.K. Gibson Graham and their work because of you. It was in my last year at work, my conundrums around the totalizing effects of capital were so weighing so heavily on me that in one of our conversations, Tara said, have you looked at this work? And then I had, and I couldn't look back after. It really gave me a lot more sort of hope to continue in my research. So I found the work really compelling, but I noticed that So when I speak to caution, it relates to this fact that I myself always kind of look back to enclosure as something that capitalism always tries to perform, and Gibson Graham's sort of articulation, as you noted yourself, are really, yes, like they're really rosy and hopeful in embracing the alternative and the fringe and the kind of marginal as something that's already kind of as the already existing revolution in a sense. But I have been reading some recent work also by, for instance, geographers Jessica Dempsey and Rosemary Collard, who are pointing out that Gibson Graham were writing in a specific moment in time, and that what their work is really useful for is to provide this hope. And at a descriptive level, it also gives us sort of it gives communities and those who want to, in a sense, not a roadmap, but some tools for organizing and and commoning, and building solid different kinds of economic models. Those to participate and fill this create this hybrid economy. But what they don't always do so well is kind of explain why we continue to have these recurrent problems of enclosure, of appropriation, and and so I go back then to some of this more classical feminist political economy literature. For instance, Miriam's work, which I mentioned, as better around, or not better, but just as also providing some a little bit more analytical apparatus to understand why those efforts and those alternatives tend to still have to try to always outrun this kind of process of enclosure. And so with capitalism trying to totalize, but not always being like not being fully successful. So I don't know if I'm even answering your question, but you mentioned, how do I do this? How do I practice discussion? I guess, yeah, like as I said, sort of conceptually thinking back to keeping in mind the fact that trying to think about the ways in which those practices of commoning can be appropriated and co-opted in some ways. And so what I mentioned, as I mentioned at the end, I think one of the things to explore that would be interesting and useful is how the current, or the in the last few years, this emphasis on supporting and spreading and kind of mainstreaming, in a way, social enterprises, social solidarity economies, cooperatives, that, you know, relatively mainstream level policy making bodies are pushing. You know, how is this a form? You know, how is this a form of mainstreaming transformation, or really folding it in? Like, to what extent is that a limitation, or you know, where are the limits and the potentials in that? So I don't think I'm answering your question that clearly, but those are just some thoughts. And what final thing I wanted to say is that this idea that any property can be commoned, any type of property can be commoned, is actually some of the recent work from Gibson, Cameron, and Healy is more specifically related to commoning in relation to the kind of solidarity and hybrid economies that they advocate otherwise, and they talk about kind of more than human commoning communities, etc. But they also talk about this distinction between kind of commons as a property regime, but also commons as a practice, and then this practice-based commons conceptualization is where, you know, any property can be commoned, whether or not it's you know, private, public, or some other type of property. So I'm gonna stop because I'm going on too long and not really answering your question anyway.
No, that's brilliant, Ania. Thanks. And I like it. Yeah, I haven't read some of the more recent stuff. And I think it's a kind of resistant notion of like, well, you can still comment that. Doesn't matter who owns it. Is actually, yeah, quite good. Cool. Paolo, anybody else? Yeah, go ahead.
Yes. Thanks, Tara. Thanks also for sharing that reference. I didn't know that book, and I will look at it. But in a way, I think I do agree that there could be authentic forms of collaborative economy, genuinely alternative to capitalism. But I have some resistance to the temptation to expand the qualification as commons to different types of organizational and organizational conditions that are not strictly related to the protection of a common good for current and future generations, because otherwise I'm afraid that the concept could lose its specificity, at least from strictly legal point of view. And if all is a commons, then nothing is a commons, and the idea of commons could be instrumentalized and even be subjected to manipulation. And this is also true when it comes to solidarity within any type of organization. Solidarity can be debased. It can be instrumentalized for non-solidaristic purposes, unfortunately. If we say organization, we say hierarchy, unfortunately. So the iron law of oligarchy, it's there. And as long as the iron law of oligarchy in any kind of organization is there, then I think that in this case, classical labor law should be there again to redress inequalities of bargaining power, to bring solidarity within the employment relationships in respective of the type of organization the work is performed. I think I will look at the reference that you mentioned, but in a way, I feel that the possibility that all successful institutions are also coercive, and the burden of coercions tends to fall unequally on those who are less powerful in any kind of organization. I think that this issue has been neglected in both commons theory and in cooperatives theory. Yes, I'm not sure I have answered your question, but yeah.
No, you have, and I think that's a tension that a lot of people are running up against as well. You know, that the protections that have come from effectively, like, you know, a history of exploitation are really important, and we don't necessarily want to, like, you know, abandon them. And also, you know, I think one of the problems that happens for like small cooperatives, for example, is like it's difficult to abide by those kinds of regulations because they're in a sense designed for much larger sorts of organizations. And I think you're right that not enough thinking has been done about how to navigate that without just kind of throwing those gains that have been made in respect of capitalism to the wind. Yeah, Vladimir, Miriam, Andrea. Sorry, and I'll look for other questions as well in the meantime.
Yes, I'll be very brief, and then Andrea and Miriam will join me. Thanks, Tara, for the question. It's a very valid question, and the historical example that you've given from the UK, and actually, I'm wondering whether we can speak of the history of the cooperative, or we have to speak of the many histories of the many forms of cooperatives, because I don't know, the French examples with occupying workplaces after the French Revolution, or the US sort of formation of cooperatives after strikes in the 18th, 19th century, or even the more recent historical example that Ania mentioned with the recuperated factories in Argentina. I think they, given the historical socioeconomic circumstances of the places, sort of really offer different histories of the cooperative form, which sort of, as an idea, at least always sort of carries, at least as a aspiration, some form of, let's say, worker solidarity, collectivity, sort of collective decision making, deciding what, when, under what conditions is going to be produced. So I think these are, of course, there are negative examples or negative sort of even ideas that have driven formation of different cooperatives in the end. But I think that's why we decided to go with this exercise of going with some sort of a taxonomy. And the idea of the exercise was not to map or to have a taxonomy, and then it was not a sort of search for the ideal type of cooperatives, but just to look into different historical contexts, also from contemporary ones, and to see what kind of values and in the way they have materialized can offer some insight or a lesson. But yeah, again, your question is absolutely on point, because we have to be cautious, because not to sort of get across a message that we are sort of idealizing the cooperative form as the sort of the cure for subordination or hierarchy in regular work relations, but we are also sort of interested to see how this once idea that has been also reworked throughout history is able to adapt or to material or to be even captured and basically exploited and abused for the opposite purpose. So that's it. Caution and exploration in a way. So maybe, yes, Andrea.
Yeah, go for it. Sorry.
Yeah, no, thanks. I mean, I am really enjoying the conversation, the discussion, and I mean, I was not prepared to present, but this question that Tara you made, I think, let me also think about the reasons why we engaged in this kind of research, because I think that what we aim, at least what we have as a goal, is not to, as Vladimir said, to idealize the cooperatives as a form of organization, but to take the cooperative as the form that aims to somehow create non-authoritarian workplaces, and to think, okay, what then would be the role of labor law? And the role of labor law in this context would be exactly to avoid the exploitation of workers within the cooperative, the disciplining of the workforce, like you said, in the historical context of the UK. So I think it's starting from the overarching overall aim of cooperatives, and then imagining where labor law can step in order to actually protect and safeguard the empowering tension of the workers' cooperative as a form, as organization.
Miriam, did you want to comment at all?
No, but I think it's I think the point you're making, that of the cooperative, the example that they were disciplining, I think this is a very helpful suggestion for us to be even more cautious when we are developing the taxonomy, to pay attention to historical practices or even practices today where cooperatives are not as worker-friendly, if I may say so. So I think this is a very, very valuable point we will look into. Thank you.
You know, of course, I think your response is really good as well, because I think it's much more about what people actually do with them than, and their histories in particular places, than like where the kind of form itself might come from, and like the fact that it kind of consolidated around the same time as the company. Again, like at least in the UK. But I keep thinking about, you know, like the role that cooperatives played, for example, in the expansion of empire, where like the cooperative is, it's kind of seen as this like more natural form that can reflect indigenous values or something like that, and in that way then becomes a kind of tool of colonialism. And there's a kind of a bunch of different sorts of examples like that, and I worry sometimes about kind of inadvertently sort of naturalizing that form, as opposed to also seeing it as a product of like 19th century political economy and the capitalist system, and a particular way of thinking about things that it, you know, then constrains what we imagine they can do and what it is we're trying to achieve by having them. And I think, yeah, your response, I'm on board with everything that you guys are saying, because I think that's why I'm interested in them as well, and interested in these kinds of tensions that come up. So I think we do have a question. How much time do we have? About 15 minutes. So, I mean, obviously, you guys should feel free if you want to respond to each other. There's a question here from Flavia. Ania, you may have already seen it. So, Ania, how can we regulate labor as a common without falling into epistemic extractivism or homogenizing, once again, the epistemology of labor law, centralizing it in the hegemonic conception? So if you want to give that some thought.
I'm just gonna give it a thought for I'm gonna read it for a moment, because I haven't, I didn't see it earlier. I didn't scroll up. So if there are other questions, go with those, and I will just.
Can I follow one of the Vladimir's comments? Final research question.
Go for it.
About what's the role of organized labor unions? What can they do in relation to cooperatives? I want to be again provocative. If we look at collective bargaining covering cooperatives, you have on the one side employers associations. On the other side, there are unions signing collective agreements that are applied, at least in coordinated market economies, Italy, Germany, France, etc. You have sectoral collective bargaining covering cooperative workers. So again, there you have two sides. Is it like a sign that you still have confrontational relationships within cooperatives? The fact that you have to redistribute power and resources through collective bargaining and regulate a given labor market with a central intervention by trade unions on the one hand and employers associations on the other hand.
Do you want to answer that?
Yeah, no, that's definitely something that it's a valid point, and I agree. I mean, there is. I mean, it's a provocative, but also like it really resonates in a way where some where like there is certainly a space for intervention from a more sort of central institutionalist level. At the same time, it's also opposite of the aspirations to sort of have this horizontal structure that regulates more or less everything that happens to the economic production, but also to the work relations internally. But yes, definitely taking this on board. I don't know if whether Andrea or Miriam would like to say something on it, but it's definitely one of the questions that that kept us thinking while we were working on the paper.
So, Ania, do you want to come back up with Flavia's question, and then I'll ask Adele's question?
Yeah, Flavia, it's a very hard question, and yeah, I'm not surprised that you've asked me this question. I should be better prepared to answer it. I guess, yeah, I don't know how we regulate labor as a common to begin with. I suppose, you know, the title of my talk was thinking about labor as a common and its implication for regulation. But I guess what I'm more interested in is thinking about not so much folding the commons fully into the narrative of labor law itself, the hegemonic narrative of labor law, but thinking about practices of commoning as those counter-hegemonic kind of alternatives that already coexist with labor law itself, and thinking about how we may learn from those counter-hegemonic practices. And this means, of course, acknowledging and looking to the kind of context and kind of different ontological and epistemological positions where commoning as a practice is historically prevalent, be it indigenous sort of ways of being and living and making a living or supporting livelihoods, like in Canada, where I am, the work of peoples like John Burroughs or Leanne Simpson, who don't specifically look to labor practices, but they look to ways of being in the world and kind of which also involve labor and kind of caring for each other, communities, resources, etc. So it's obviously there is much we can learn from yes, those knowledges and ways of thinking about labor in relation to kind of commons more generally or community. But I think what I find useful in this idea of labor as a commoning practice is that it is not something that exists solely. We don't have to look for these examples just in history or in sort of subsistence economies, but as sociologists of work have documented, commoning practices take place in various forms in workplaces kind of everywhere. And so yeah, again, I'm not trying to fold those into the mainstream narrative of labor law, but rather actually think about how they, you know, think of them maybe, and ways in which law facilitates or stands in the way of those kinds of alternatives as a way to critically engage with the discipline of labor law itself. And maybe from those grounded practices, there is some, and those other kind of epistemological positions, there is a way to feed into and inform labor law in a way that doesn't get it, you know, doesn't sort of reproduce hegemony, but actually tries to transform it. But anyway, another long-winded answer, because that is a really hard question. Perhaps you have ideas on this, Flavia, because I know you do. I know you work on kind of thinking about, your research is on thinking about labor law from a very different epistemological perspective.
Okay, thanks, Ania. Unfortunately, I don't think we have a mechanism to allow Flavia to speak, although that might be nice. So I'll ask Adele's question now, which I think is for everyone. Is engaging the cooperative and collaborative commons the most generative approach to addressing the core challenge of subordination? And I think that's for any and everyone. I suppose,
it's a very hard question.
I suppose, as opposed to what? Like, what else? I don't know. Where else might we look for a generative approach to addressing the core challenge of subordination?
Yeah, I'm just gonna be super brief, but because I want to hear others. It's also a really hard question, but on the other hand, my answer would be, why not there? And even if it's not the most generative approach to engaging and thinking and kind of, you know, maybe as a point of critique. I mean, mind you, not that labor law needs more critiques. There are already plenty, but whether it's from that perspective of critically engaging with it and yeah, I just it may not be the most generative, but it seems to me that an approach that starts out from the assumption that, you know, that people at work relate to each other in a non-authoritarian and kind of way, and that solidarity and cooperation are the key values that inform how they work together and how they reproduce a community together, whether the community at work or more broadly. I mean, that seems to me like a good way of addressing subordination. But of course, then, yeah, the problem which already my kind of friends here identified is that this sits really funnily with labor law, because labor and employment law assumes subordination. And so it's almost like, yeah, it assumes subordination and just tweaks around the edges to try to undo it, I think. And so, but I mean, that's a maybe an unfair point, but I think it's because it's very difficult to actually do that. But anyway, I don't know if it's the most generative, but it is one way of doing so that isn't done that often in our community.
Would anyone else like to answer?
I might add something brief to that, and I think more or less my answer will align to Ania's. And I think it's a very good question, though. I mean, also for us who are sort of engaging with these kinds of topics, okay, whether it's worth investing sort of long-term energy into projects like this, and whether they are the most generative approaches. But I think it's a good starting point, and to look into an alternative sort of to what we have compared to the standard capitalist mode of production, and a bit sort of in the sense of Gibson Graham and the diverse economists sort of literature, which argues that this alternative to capitalist sort of economic structures there are plenty, and sometimes yes, they're worth of being explored, and in a sense to see whether insights can be drawn, and to what and then once we understand how some of these alternative modes of economic activities work, then we can maybe in a second step think how to mainstream them more in a society. But I think so the first step that we are all sort of engaging in here, and to see what insights these commoning practices or cooperatives are offering, I think it's a first step towards something that can become generative. I hope, at least.
Paolo,
I think if we take the commons and cooperatives as ideal types or even utopias, the origin of this panel was within a group of scholars, except Ania, but she was also engaged in these kind of discussions. A group of scholars that are trying to engage in the analysis of utopias from the point of view of labor law. And so this panel somehow follows the conversation that we had at the Labor Law Research Network about utopias and labor law. So if we consider collaborative commons and cooperatives in their ideal, typical, or utopian dimensions, I think the answer would be definitely yes. So they can be the most generative approaches or ideal types or utopias to redressing the core challenge of subordination. But then if we really look at the concrete experiences of both the commons and differently cooperatives, we will still find subordination as long as there is a property background in the organization of a given activity. If there is property, in my opinion, there will always be subordination. Otherwise, if we assume, but it's conceptually tricky, that if we assume that the commons are the opposite of property, then I can say we should distinguish between the commons and cooperatives. Cooperatives are owned. They have a property nature. If we accept the assumption that the commons are the opposite of property, then we could argue that commons could be a model to challenge subordination.
Okay, so I think we're at the end of our time. I don't know if we're allowed to run over it all, or if anyone wants to, just in order to come back on that question. Otherwise, yeah, okay. All right, thank you everyone for a really fruitful, I think, discussion. And I hope there is more to come on this theme. It's really exciting. Thank you everyone for joining us. Thank you so much to our speakers for their brilliant papers. Enjoy the rest of the conference.